Take a deep breath. This is going to be the lecture you always wished was boring enough to put you to sleep. No need to take notes. You won't remember this anyway. Now that you're comfortable, let's begin. Rule 1. Citation, application, and interpretation. Citation. Title 1.011. These rules may be cited as the Rules of Civil Procedure. Subdivision 2. In these rules, A. All the provisions identified by the same number to the left of the decimal point comprise a rule. For example, Rule 1, which consists of rules 1.01 to 1.09. B. A provision identified by a number with a decimal point is a rule. For example, Rule 1.01. And C. A rule may be subdivided into 1. Subrules, 2. Clauses, 3. Subclauses, 4. Paragraphs, 5. Definitions. Alternative method of referring to rules. 3. In a proceeding in a court, it is sufficient to refer to a rule or subdivision of a rule as rule, followed by the number of the rule. Subrule, clause, subclause, or paragraph. Application of rules. Court of Appeal and Superior Court of Justice. 1.021. These rules apply to all civil proceedings in the Court of Appeal and in the Superior Court of Justice, subject to the following exceptions. 1. They do not apply to proceedings in the Small Claims Court, which are governed by Ontario Regulation 258-98, Rules of the Small Claims Court. 2. They do not apply to proceedings governed by Ontario Regulation 114-99, Family Law Rules, except as provided in those rules. 3. They do not apply if a statute provides for a different procedure. Combined proceeding in Family Court of Superior Court of Justice. 1.1. Where a proceeding combines a matter to which the family law rules apply with a matter to which these rules would ordinarily apply, the parties may agree, or the court on motion may order, that the family law rules apply to the combined proceeding or part of it. Definitions. 1.031. In these rules, unless the context requires otherwise, action means a proceeding that is not an application and includes a proceeding commenced by A. Statement of claim, B. Notice of action, C. Counterclaim, D. Cross-claim, or E. Third or subsequent party claim. Appellant means a person who brings an appeal. Appellate court means the Court of Appeal or the Divisional Court, as the circumstances require. Applicant means a person who makes an application. Application means a proceeding commenced by notice of application. Certificate of Appointment of a State Trustee means letters probate, letters of administration, or letters of administration with the will annexed, and includes a small estate certificate or amended small estate certificate 74C, 74.1C, or 74.1F. County includes a district, a regional or district municipality, and the City of Toronto. Court means the court in which a proceeding is pending, and in the case of a proceeding in the Superior Court of Justice, includes an associate judge. Defendant means a person against whom an action is commenced. Deliver means serve and file with proof of service, and delivery has a corresponding meaning. Disability, where used in respect of a person, means that the person is A. a minor, B. mentally incapable within the meaning of Section 6 or 45 of the Substitute Decisions Act 1992 in respect of an issue in the proceeding, whether the person has a guardian or not, or C. an absentee within the meaning of the Absentees Act. Discovery means discovery of documents, examination for discovery, inspection of property, and medical examination of a party, as provided under Rules 30 to 33. Document includes data and information in electronic form. Electronic includes created, recorded, transmitted, or stored in digital form or in other intangible form by electronic, magnetic, or optical means, or by any other means that has capabilities for creation, recording, transmission, or storage, similar to those means, and electronically has a corresponding meaning. Factum includes a book of authorities if one is required by Rule 4.06.1. Hearing means the hearing of an application, motion, reference, appeal, or assessment of costs, or a trial. Holiday means A. any Saturday or Sunday, B. New Year's Day, B.1 Family Day, C. Good Friday, D. Easter Monday, E. Victoria Day, F. Canada Day, G. Civic Holiday, H. Labor Day, I. Thanksgiving Day, J. Remembrance Day, K. Christmas Day, L. Boxing Day, and M. Any special holiday proclaimed by the Governor General or the Lieutenant Governor. And where New Year's Day, Canada Day, or Remembrance Day falls on a Saturday or Sunday, the following Monday is a holiday, and where Christmas Day falls on a Saturday or Sunday, the following Monday and Tuesday are holidays, and where Christmas Day falls on a Friday, the following Monday is a holiday. Judge means a judge of the court, but does not include an associate judge. Judgment means a decision that finally disposes of an application or action on its merits and includes a judgment entered in consequence of the default of a party. Lawyer means a person authorized under the Law Society Act to practice law in Ontario. Lawyer's office means the office of the lawyer of record, as set out in the last document, filed by him or her. Limited scope retainer means the provision of legal services by a lawyer for part, but not all, of a client's legal matter by agreement between the lawyer and the client. Motion means a motion in a proceeding or in an intended proceeding. Moving party means a person who makes a motion. Order includes a judgment. Originating process means a document that commences a proceeding under these rules and includes A statement of claim, B, a notice of action, C, a notice of application, D, an application for a certificate of appointment of a state trustee, a small estate certificate, or an amended small estate certificate. E, a counterclaim against a person who is not already a party to the main action, and F, a third or subsequent party claim, but does not include a counterclaim that is only against persons who are parties to the main action, a cross-claim, or a notice of motion. Partial indemnity costs mean costs awarded in accordance with Part 1 of Tariff A and on a partial indemnity basis has a corresponding meaning. Person includes a party to a proceeding. Plaintiff means a person who commences an action. Proceeding means an action or application. Referee means the person to whom a reference in a proceeding is directed. Registrar means the registrar of the divisional court or court of appeal, or a local registrar of the Superior Court of Justice, as the circumstances require. Respondent means a person against whom an application is made or an appeal is brought as the circumstances require. Responding party means a person against whom a motion is made. Statute includes a statute passed by the Parliament of Canada. Substantial indemnity costs mean costs awarded in an amount that is 1.5 times what would otherwise be awarded in accordance with Part 1 of Tariff A, and on a substantial indemnity basis has a corresponding meaning. Timetable means a schedule for the completion of one or more steps required to advance the proceeding, including delivery of affidavits of documents, examinations under oath where available, or motions, established by order of the court or by written agreement of the parties that is not contrary to an order. Will includes any testamentary instrument of which probate or administration may be granted. Interpretation. General Principle 1.041. These rules shall be liberally construed to secure the just, most expeditious, and least expensive determination of every civil proceeding on its merits. Proportionality 1.1. In applying these rules, the court shall make orders and give directions that are proportionate to the importance and complexity of the issues and to the amount involved in the proceeding. Matters not provided for. 2. Where matters are not provided for in these rules, the practice shall be determined by analogy to them. Party and party costs. 4. If a statute, regulation, or other document refers to party and party costs, these rules apply as if the reference were to partial indemnity costs. Solicitor and client costs. 5. If a statute, regulation, or other document refers to solicitor and client costs, these rules apply as if the reference were to substantial indemnity costs. Order on terms. 1.05. When making an order, under these rules, the court may impose such terms and give such directions as are just. Forms. Use of forms. 1.06.1. The forms prescribed by these rules shall be used, where applicable, and with such variations as the circumstances require. Table of forms. 2. In these rules, when a form is referred to by number, the reference is to the form with that number that is described in the table of forms at the end of these rules and is available on the internet through www.ontariocourtforms.on.ca. Practice directions. Definition. 1.071. In this rule, practice direction means a direction, notice, guide, or similar publication for the purpose of governing, subject to these rules, the practice for proceedings. Court of Appeal. 2. A practice direction for proceedings in the Court of Appeal shall be signed by the Chief Justice of Ontario, Superior Court of Justice. 3. A practice direction for proceedings in the Superior Court of Justice throughout Ontario shall be signed by the Chief Justice of the Superior Court of Justice. 4. A practice direction for proceedings in the Superior Court of Justice in a region shall be signed by the Regional Senior Judge and countersigned by the Chief Justice of the Superior Court of Justice. Filing and publication. 5. A practice direction shall be filed with the Secretary of the Civil Rules Committee and published on the Ontario Courts website. Effective date. 6. A practice direction does not come into effect before it is filed and published in accordance with Subrule 5. Method of attendance at hearings, etc. Attendance before the court. 1.08.1. A party seeking a hearing or other step in a proceeding that permits or requires the attendance of parties before the court shall, in the forms or other documents required under these rules, to be filed in advance of the hearing or step, specify by which of the following methods the party proposes that the parties attend at the hearing or step. 1. In person. 2. By telephone conference. 3. By video conference. Exception. Court of Appeal. 2. This rule does not apply with respect to proceedings in the Court of Appeal, which may be heard as directed by the court. Exception. Case conferences. 3. This rule does not apply with respect to case conferences which shall be held by telephone conference unless the court specifies a different method of attendance. Objection. 4. A party who wishes to oppose the proposed method of attendance shall deliver a notice of objection in Form 1A before the earlier of A. 10 days after the document specifying the proposed method of attendance was served on the party, and B. 7 days before the hearing or step. Objection to be dealt with at case conference. 5. If a notice of objection is delivered, the court shall order a case conference under Rule 50.13 to deal with the objection. Method to be determined by order. 6. At the case conference, referred to in Subrule 5, the court shall make an order directing the method of attendance at the hearing or step. In doing so, the court shall consider, as applicable, A. The availability of telephone conference or video conference facilities. B. The general principle that evidence and argument should be presented orally in open court. C. The importance of the evidence to the determination of the issues in the case. D. The effect of a telephone conference or video conference on the court's ability to make findings, including determinations about the credibility of witnesses. E. The importance, in the circumstances of the case, of observing the demeanor of a witness. F. Whether a party, witness, or lawyer for a party is unable to attend by a method because of infirmity, illness, or any other reason. G. The balance of convenience between any party wishing the telephone conference or video conference and any party or parties opposing. And H. Any other relevant matters. No objection. 7. If no notice of objection is filed, the parties are deemed to have agreed to attendance by the proposed method, and unless the court directs otherwise, the hearing or step shall proceed by that method. Attendance at mediations, oral examinations. 8. In the case of a mediation, under Rule 24.1, 75.1, or 75.2, or of any step to which Rule 34 applies, the mediation or step shall be held by a method of attendance referred to in Subrule 1, determined in accordance with the following rules. 1. If the parties and any other person who is required to attend the mediation or step agree on the method of attendance, the mediation or step shall be held by that method. 2. If the parties and any other person who is required to attend the mediation or step fail to agree on the method of attendance. 1. In the case of a mediation to be held under Rule 24.1, or a step to which Rule 34 applies, one of the parties shall request a case conference under Rule 50.13 for an order directing the method of attendance. Or 2. In the case of a mediation to be held under Rule 75.1 or 75.2, the court shall, on the motion for directions under Rule 75.1.05 or 75.2.03, as the case may be, Make an order directing the method of attendance. 3. In making an order directing the method of attendance, the court shall consider any applicable factors listed in Sub-Rule 6. Transition references under the Solicitors Act. 9. Rule 1.08.1 as it read, immediately before it was revoked, continues to apply with respect to a reference under the Solicitors Act of a lawyer's bill for assessment if a party to the reference made a request under that rule before the day Section 1 of Ontario Regulation 689/20 came into force. Communications out of court. 1.09. When a proceeding is pending before the court, no party to the proceeding and no party's lawyer shall communicate about the proceeding with a judge or associate judge out of court, directly or indirectly, unless A. all the parties consent in advance to the out-of-court communication, or B. the court directs otherwise. Alright, that's it for now. Not that anyone's still awake to hear it. I'll stay up reading so you don't have to. Good night.